Hi, my name is Bray Sinclair and I'm a solicitor in the Mental Health Advocacy Service. I've worked in mental health law for over 10 years and I appear regularly in applications and hearings before the Mental Health Review Tribunal, the Guardianship Division of the New South Wales Civil and Administrative Tribunal, where the majority of guardianship law is practiced, and the Supreme Court. Guardianship law is the law which gives people, including family members or the public guardian, the power to make decisions on behalf of other people who lack capacity to make decisions in certain areas of their life. Types of decisions may include where to live, how to manage money, consent to medical and dental treatment, who the person can have access to and where they can go, and activities the person can do at home or in the community. The Guardianship Tribunal can make the decision on whether the person lacks capacity and who should be the decision maker on behalf of that person. This presentation is for new lawyers appearing in guardianship matters. I like to call it a guardianship toolkit. Your toolkit will have your where-to guide, some general information on guardianship and financial management, the role of the separate representative, known as the SEP Rep, common terms, and common problems you might face. Number 1 is your where-to guide. Where to find the law, where to find information on the jurisdiction, and where to get help when you just need to talk. The most important piece of legislation is the Guardianship Act 1987, New South Wales. And the most important sections of the Act are Section 3, Definitions, Section 4, General Principles, Section 14, headed Tribunal may make guardianship orders or considerations the Tribunal applies in deciding whether to make the guardianship order. Part 3, Guardianship Orders. Part 3A, Financial Management. And Part 5 addresses medical and dental treatment. Other pieces of legislation is the Civil and Administrative Tribunal Act 2013, the regulations and the rules, which sets out the practice and procedure of the tribunal, and the New South Wales Trustee and Guardian Act 2009 and its regulations. Reading cases is one of the best ways of familiarising yourself with the rules, law, and how the tribunal talks about itself and the applications before it. There are literally hundreds of decisions which discuss all aspects of guardianship. Since all decisions and reasons of the tribunal are put in writing, you will find these cases at the New South Wales Case Law website. In the resources on the webpage, you can access a list of important case law that you should be familiar with. For a general overview of the jurisdiction and its practical operation, the New South Wales Civil and Administrative Tribunal (NCAT) website contains information sheets on every conceivable event, including legal issues, that may arise in a tribunal hearing. It also contains forms, procedural directions and guidelines applicable in the Guardianship Division, including the guideline on representation, which you must read if you are appearing as a separate representative. There is a guideline also on applying for costs, adjournments and confidentiality, privacy and publication. The assumption is that people should represent themselves in this jurisdiction, and lawyers are only able to appear by leave or order of the tribunal. The website is set up for self-represented litigants and it is easy to read and navigate. It is a useful resource to direct people to who want further information about the jurisdiction. Very importantly, if you need to talk to someone, call the Mental Health Advocacy Service and ask to speak to one of our senior solicitors. You have to remember that guardianship work is exceptionally specialised. There are not many practitioners who appear in the tribunal, and guardianship work is also solitary. You'll be working by yourself and often won't have colleagues that you can discuss your issues with. Ring the Mental Health Advocacy Service and see if we can assist or find someone that can. If your question is a procedural one related to the matter that has been assigned to you, ring the tribunal officer who is managing the matter on the number that should have been provided to you when the matter was assigned to you by legal aid. If you don't have that direct number of that particular tribunal officer, obtain it when you email or call the tribunal next. It will come in very handy in times of urgent need. Questions relating to grants of legal aid, including engaging interpreters or other disbursements. You will still need to contact the Legal Aid Grants Department and ask to speak to the Civil Law Department if you are wrangling with Atlas. If someone asks you what the policy is relating to grants of legal aid in guardianship matters, refer them to the Legal Aid website and click on the tabs for Lawyers, Policy Online, Policies, Chapter 6, and then 6.16, which addresses guardianship matters. For a really good overview of applying for guardianship and how it works in New South Wales from the point of view of families or potential applicants, you can find that on Legal Aid's Law for Community Workers YouTube webinars. It's called Guardianship, Busting the Myths. The second item in your toolkit is information about guardianship law and financial management. The guardianship law that I'm referring to relates to adults under guardianship and not children. This is found at Section 9 of the Guardianship Act, New South Wales. A guardianship order can't be made for a person who is under the age of 16. This is done under separate legislation, which is not relevant for our purposes today. Guardianship law covers all aspects of a person's life. You should note that there are separate tribunal application forms for financial management orders and another form for everything else. Financial management is found at Part 3A of the Guardianship Act, and everything else is obviously found in the rest of the Act. Just so you know, the Mental Health Review Tribunal can also make financial management orders, but they don't have the power to appoint separate representatives, so it's unlikely that you'll have much to do with those. You probably already know this, but almost without fail, you're going to be asked to explain at some stage the difference between an enduring power of attorney, enduring guardianship, a guardianship order, and a financial management order. Very simply, the enduring power of attorney and enduring guardianship are documents signed by people when they have the full capacity to understand, appoint, and sign the documents. The guardianship order and financial management orders are both made in the guardianship division and are made for people who have lost capacity to make their own decisions. The enduring documents are usually prepared and signed in a solicitor's office. The guardianship order and financial management order are made in the tribunal. You've probably been assigned a grant of legal aid to appear as a separate representative before the tribunal. So let's look in more detail at the role of the SEP Rep. This in the Guardianship Division guideline headed Representation. Particularly have a look at page 7, paragraphs 41 to 48. The information on the appointment and role of the SEP Rep is detailed, specific, and must be read every time, or at least for the first few hearings that you appear in. The tribunal will not hesitate to ask you if you have read it if they feel that you have not accomplished the tasks that you need to perform. Just briefly, only the tribunal can appoint a SEP Rep. They are different from legal reps and Mackenzie friends. In fact, the SEP Rep is like counsel assisting the Royal Commission. You are there to investigate, collate, formulate submissions, and assist at the tribunal hearing. Remember, the tribunal is an inquisitorial one, and as such, it actively investigates the matters before it. You do not represent any of the parties, and you do not act on instructions of any party. You are there to get information and present it to the tribunal so the tribunal can make a decision in accordance with the legislative requirements, which roughly boils down to the best interest test. I'll talk about that shortly. Some tribunal panels do not involve the SEP Rep in the hearing very much. Other tribunal panels can request submissions on issues of law, clarification of the evidence, as well as examination of the parties. The basic task for the SEP Rep is to visit or speak to the subject person, or the person that the application is about, to speak to the parties involved with the subject person, to collate evidence, and to formulate submissions on what you think, based on all the available information, would give paramount consideration to the welfare and interests of the subject person, whilst also taking into account the other principles that are set out in Section 4 of the Guardianship Act. Again, I can't stress enough, read the representation guideline. Apart from setting out information for the SEP Reps, it also sets out what the tribunal considers when it receives an application for a lawyer to legally represent a party, as well as the role of lawyers as Mackenzie friends or legal support persons. When you appear as a SEP Rep at the tribunal, written submissions are up to you. They are certainly not expected. However, if the issues before the tribunal are complex or lengthy, then written submissions might be useful. And you also might be wondering whether to go formal or informal when appearing at the tribunal. Look at the Civil and Administrative Tribunal Act, in particular sections 35 and following. The rules of evidence don't apply in the tribunal. The tribunal can inform itself on any manner as it thinks fit, subject to the rules of natural justice. And helpfully, the Representation Guardianship Division Guideline, August 2017, gives an answer to how to address the tribunal members. See paragraph 37. The fourth area I would like to explore in the toolkit is common terms used in guardianship that you should become very familiar with. The first is best interest. This is the most important term of them all. Section 4 of the Guardianship Act, A to H, sets out the considerations that the tribunal exercises when thinking about what is in the subject person's best interest. The list includes the subject person's welfare and interests as being paramount considerations, as well as their liberty, protection against neglect and exploitation, as well as preserving family, cultural and linguistic environments. And don't forget section 14. You'll need to look and address that section as well. For financial management applications, look at Part 3A, headed Financial Management. This discrete area has its own rules that need addressing by the SEP Rep and the tribunal. Section 25B of the Act essentially repeats the requirement that before an order is made, there has to be evidence of the subject person lacking capacity to manage their money, that they need someone else to help them manage their money, and that it is in their best interest that the order be made. The next definition is the definition of a person in need of a guardian, also referred to as the subject person. This is in Section 3 of the Act. It says that a person in need of a guardian means a person who, because of a disability, is totally or partially incapable of managing his or her person. There has to be evidence of capacity or incapacity before the tribunal, which is usually in the form of a medical report. The term "a person who has a disability" is defined in the Act as a reference to a person who is intellectually, physically, psychologically or sensorially disabled, who is of advanced age, who is a mentally ill person, who is otherwise disabled and who, by virtue of that fact, is restricted in one or more major life activities to such an extent that he or she requires supervision. Functions. This is what people apply for when making a guardianship application in respect of a person who is in need of a guardian. Section 3, subsection 6, states that A reference to a function includes a reference to a power, authority and duty, and B, a reference to the exercise of a function includes, where the function is a duty, a reference to the performance of that duty. Remember how I earlier said that there was a form for financial management orders and then there was one form for everything else? Well, that is because applications for orders over a person who has lost capacity to perform tasks themselves are limitless. It's true. The tribunal actually theoretically has the power to make orders granting unlimited, unfettered powers over a person. It even has a word in the Act for it. It's called plenary power. Of course, the tribunal does not, in practice, ever exercise its unlimited power, and generally it'll limit itself to the following areas when appointing functions: accommodation, or where the person will live; coercive powers, the power to retrieve a person and return them to their accommodation; healthcare consents; services; advocacy; legal, and restricted practices. New functions are developed all the time to reflect current social and economic conditions. For instance, recently a new function was added to an existing guardianship order in the form of a COVID-19 function. See the cases in the NCAT website Case Digest for an overview of functions and their evolving nature to respond to current needs. The final term we'll look at today is consent to medical treatment. The tribunal also gives consent to major medical treatment and special medical treatment on behalf of subject persons. Special medical treatment includes treatment which will render a person infertile, experimental treatment, or treatment declared by the regulations to be special treatment. There is a case in the NCAT Case Digest that discusses major medical treatment, different to special treatment. A SEP Rep was not involved, however it is an interesting case which gives an overview of this aspect of the tribunal's work. The final contents of your toolkit relates to common problems you might face. The first of these relates to getting the views of the subject person. Sometimes you are going to have to use all your skills of communication to enable you to do this job. I've come across people with severe intellectual disabilities, severe symptoms of mental illness, people with the most terrible medical conditions requiring urgent special treatment. I've driven hours to see people out in remote areas of Sydney, people living in locked group homes out in the middle of literally nowhere. I've visited subject people who are incarcerated or in hospitals. I've had to visit people's homes. The main thing is that you try and visit the person. If a phone call is all that is available, then that will have to do. But only please do what you can do safely and let the tribunal know. The second of these is engaging with clients with disabilities when you're a newbie lawyer. Every lawyer will have their own way of building rapport or a connection with the subject person. I usually find somewhere that is private and comfortable and explain to the person who I am, why I'm there, what I'm going to ask. Try to ensure as much as possible that the subject person is somewhere that they're able to speak freely without the risk of being unduly influenced by other parties in the room. If the person just wants to talk for a while, that's fine too. The people we see often spend the day being told what they can and cannot do. They might like speaking to a new face. Then again, some don't, and that's fine too. Some people will talk for 5 minutes, other people will want to talk for 50 minutes. However long you need, take it. I don't assume anything. Some people who suffer from disabilities have the most amazing skills and talents. Some are artists. One was a mathematical genius, but incapable of looking after himself in other areas of his life. I try to imagine what it would be like if I was them and some stranger was turning up saying that they want to speak to me about something that I didn't necessarily want to talk about, such as who was controlling my money. A common problem you might face is what to do if you can't manage to get in contact with the subject person. As long as you have a record of the times and methods you tried, then you have done all you can. There are just some people who can't be contacted. An example is where the subject person is aware of the proceedings and is doing everything to evade being contacted. Some people don't own a phone, or most won't answer when no caller ID is on their phone. It will be up to the tribunal to decide how to proceed. They don't often proceed in the absence of the subject person, but depending on the urgency of the circumstances, they can and will. I usually call the case manager, house manager, parents, social worker, NDIS support coordinator, whoever it is that has regular contact with the subject person first, to either make an appointment to see or call the subject person. If you don't, you'll probably never be able to contact the subject person. You have to also try and speak to all the other parties who are involved in the matter or might have some involvement. Use your judgment when deciding whether a person's input is necessary. You'll be able to get an idea from the documents provided to you from the tribunal, along with the information obtained by conversations with various people along the way. If you need to get documents but you can't obtain them from the relevant parties, you may need to request a directions hearing. Another scenario is where there is conflict between the separate representative, the subject person, or the subject person's family. The hostility to the whole application could even make the family prevent access to the subject person. Use your common sense. I believe that the tribunal is grateful for all the assistance that it can be given in a matter, but not at the expense of your safety or what is reasonable in the circumstances. If the tribunal does not feel it has sufficient information due to obstructive parties, then it can deal with this at a directions hearing or on the day the matter is listed for final hearing. Another frustrating occurrence can sometimes be when you find yourself having to explain to every party you speak to who you are, your role, what role and powers the tribunal has, what role and powers the New South Wales Guardian and Public Trustee have. Sometimes that is where referring parties to the NCAT website comes in handy. And don't be alarmed if you find yourself an unwitting mediator between warring family factions. If you feel it is in the best interests of the subject person, for there to be consensus among parties on certain issues, then this will assist in the resolution of the application before the tribunal. You can cautiously proceed. But sometimes trying to find consensus is impossible and you haven't been appointed to perform miracles. If you hit a snag and you don't know what to do, you can always ring the senior solicitors at MHAS and discuss the conundrum with them. I personally find guardianship work rewarding, and I really hope you do too. And I hope that you've found useful tools and information in this guardianship toolkit. Guardianship work is both interesting and challenging. The people involved come from a wide variety of social and economic settings. They've been diagnosed with a myriad of different disabilities and are mostly happy that someone has taken the time to speak to them and find out what they want.